called this press conference today to discuss the decision to not cross the charges against Rita Crundwell. I have a prepared statement to give to you guys, and then I'll take any questions that you might have. In determining whether or not to proceed with state charges against Rita Crundwell, I've researched Illinois law. I've considered the federal sentence. I've discussed it with colleagues, and Mr. Thompson and I did a 402 with Judge Jacobson. The basis of the decision is made based on the length of the federal sentence, the fact that there's already a restitution order and forfeiture order entered, and the fact that the state charges will not bring any further penalties or any more restitution than already has been ordered by the federal court. In His Honor, Philip Reinhardt's decision, he made it very clear that he took into account the entire crime of Ms. Crundwell's that occurred from 1988 through her arrest in April of 2012. The reason that the state charges were filed initially is because the U.S. Attorney's Office told my predecessor that they expected a sentencing range of between 100 and 120 months. And what that means is the maximum that they were expecting is 10 years. In the federal system, defendants are required to serve 85% of any sentence that's imposed, which means if she was sentenced to 10 years, she would serve 8.5 years. Mr. Dixon felt at that time that that was not enough for the crime that was committed, so we filed the state charges. In researching the Illinois Unified Code of Corrections, it's clear that the court is required to impose a concurrent sentence on Ms. Crundwell for all of the charges that have been entered. Specifically, for anyone who is a legal buff and wants to look up the statute, it's under 730 ILCS 5/5-8-1.3, and it provides that when an Illinois court imposes multiple sentences on a defendant at the same time, or imposes a sentence of imprisonment on a defendant who is already subject to a sentence already imposed by an Illinois court, a court of another state, or a federal court, then the sentence shall run concurrently. The only exception to that rule is if there are aggravating circumstances that are outlined in the statute, and in this case, none of those factors apply. So the court would be required to enter a concurrent sentence. In the state scheme, the penalty that Ms. Crundwell faces is 6 to 30 years in prison. Because it's a non-violent offense, she would receive day-for-day credit, so the maximum she would receive is 15 years. Additionally, the legislature has reinstated the good time credit, and if she would have qualified for that, she could be entitled to an additional 6 months off of that. What that means for us is that the state sentence would run at the same time as the federal sentence. She would actually have her state sentence served before her federal sentence is complete. Additionally, there is no other restitution that would be available to enter in state court. Based on all those reasons, I've determined that it would be more of a financial burden to proceed. I feel that as my duties as State's Attorney of Lee County, one of my duties is to protect taxpayer money and to ensure that justice is served. In this case, because of the sentence that was already imposed, restitution and forfeiture are already ordered, there is nothing further that I can add to the sentence. I would like to take this time to thank the U.S. Marshals, the FBI, and the U.S. Attorney's Office for the work that they did investigating, prosecuting, and obtaining the assets and liquidating them. I'd also like to take this opportunity to call on all of the townships, municipalities, and villages in our area to come together to put together a protocol to make sure that the taxpayer money is safe.